I'm Douglas Gillies, and I've been a lawyer now for almost 40 years. And the past 15 or 20 years I've been mostly retired, but I stay current, and there's always a few cases. So that means I have to take continuing education in order to remain current with the bar. And last September I was driving to Northern California, and I was listening to a continuing education tape called The Mortgage Crisis. And about halfway through this program, I realized that I had never heard lawyers speak like this before. They weren't giving us laws, they weren't giving us strategies, they weren't telling us how we can make something right. They were just telling us that there was nothing that we could do, that the only thing a lawyer could do for someone who was in foreclosure was help them to get a modification. And they weren't being strategic, it was almost like they were whining. And it suddenly struck me about a half an hour through this program that the only way that they could be talking this way is if the system were broken, because they no longer were seeing remedies. They were just seeing devastation everywhere. And so I began to look into this to find out what in the world had caused this to happen. How could the system be broken? And that led me to learn more and more about securitization. And I began to understand that real estate law had been turned into securities during the past 10 years. And what that did was it totally turned everything upside down. You see, the real estate rules go back centuries, and everything is recorded, and it's always done in such a way that we know who owns what. It goes all the way back to when a transfer of land was done in what was called the transfer of season, where someone would pick up dirt from the land and put it in the other person's hand, and that would represent the moment of transfer of the land. In our current law, we do that by recording documents that identify who owns what. And if that changes, it's always recorded at the county seat, so the people can always go to the county and find out who owns the land. Now, for other sorts of property, such as chattels, which are things that are not attached to the land, the rules are a little bit different. And then when you get to securities, pieces of paper that represent chattels, then the rules get even looser still. But the rules about real estate never changed. With real estate, you must record changes of interest. Well, Wall Street got involved in real estate, and the banks started taking their interests in property and selling them off to Wall Street, and these interests got broken into thousands and then millions of pieces, and they were sold off to trusts on the Cayman Island, devices that were set up mostly to avoid bankruptcy and taxes, and the system started to come apart. So what we have now is a system that no longer is functioning. The banks can no longer show a piece of paper to a judge and say, this represents my interest in the land. And if you want, you can look in the recorder's office and you'll see where I acquired that interest. Ordinarily, the transaction when a mortgage was taken out is that someone would sit down with the bank, and the deal was, you lend me some money, and then I'll pay you back, and then the house will be mine. It was very simple. And the contract was based on the presumption that the person borrowing the money would have the ability and the motivation to pay back the bank so that they would own the land. The beginning of that transaction is that the person owns the land. They have the grant deed. Somebody sells them the land and they own it, and then they convey back a lesser interest on behalf of the bank, which is a deed of trust. And that deed is saying, until I pay you back, you have an opportunity to come after me and take my property if I don't pay you. So that's the deed of trust. And that's pretty straightforward. Now, let me take you back to a moment that any lawyer can remember in law school. It's where the beginning of our modern system of laws began. They teach us in law school that a contract is formed when two people sit down and develop a shared expectation that something will happen in the future. And we call that a meeting of the minds. So in order to have a contract, you have to have a meeting of minds, a shared expectation. It was several hundred years ago in England when the government decided that when two parties have a meeting of the minds, they identify a shared expectation and they offer to exchange something in value to each other. Consideration is what we call it. That in that case, the system would enforce that contract. And if one person broke the contract, the judges would enforce it and make them either do what they said they would do or pay the other party something of equal value. And that's where contracts began. So it's based on a meeting of the minds. The way things changed in the past few years is that when the person borrowing the money sat down with the bank and they said, you lend me money and I'll pay you back and then I'll own my house. What the bank was saying is, I'll lend you money, but you'll never pay us back because you can't. The payments are going to keep getting bigger and you don't have the income to pay this thing back anyway. We know you can't pay us back. So you pay us money and after a while we'll foreclose against you and then we'll own your house. So there was not a meeting of the minds. There was no shared expectation that the person borrowing the money would ever be able to pay it back. And the way this manifested itself was the banks stopped doing what we call underwriting. They stopped analyzing what the person's ability was to pay. They stopped verifying what their income was and what their expenses were. They dispensed with that entirely. And why did they do that? Because they had figured out a way to make more money if the borrower defaulted than if the borrower performed their promises. And so the bank didn't want to lend money to somebody who would pay them back. They would make much more money if they lent money to somebody who couldn't pay them back. And the way that worked was this. Number one, as soon as the bank had the promise to pay, they sold that to Wall Street. So they were just the agent. But as they were passing that paper up to Wall Street, the next thing they did was take out insurance so that if you defaulted, they would be paid the principal. So in that moment in which they were transferring the interest to Wall Street, they were giving themselves what was referred to as a credit default swap. They were giving themselves an insurance policy, guaranteeing that if, in most cases, when you defaulted, they would get paid the entire amount. So they no longer were agreeing that you would be borrowing money and paying it back. They were saying that, but they were thinking something entirely different. And when you have no meeting of the minds, there's no contract. So what does that leave on the record? You have a grant deed, which is what the person had when they went to see the bank. On top of that, you have a deed of trust, which was supported by a promissory note. But if there was no contract, which means there's no duty to pay back the bank, then the deed of trust has no meaning because its only purpose is to reinforce the promissory note. So when the banks turned everything upside down, working in partnership with Wall Street, and they figured out a way to lend money so that they would make money when the person borrowing defaulted rather than when they performed, they broke a series of agreements as to what a contract is that go all the way back to the Middle Ages. And that's why those lawyers in that continuing education conference were so baffled, because they were trying to make sense of a system that had simply blown up and no longer worked. So what's the remedy to that? In each case where the bank did not have a shared expectation with the borrower that the borrower would have the ability to pay back the loan, there's no loan. There's no security interest. The person who has the grant deed owns the land. Now we go one step further. When they handed these deeds up to Wall Street, then they were no longer taking the trouble to record these transfers of interest in the county recorder's office. They no longer were identifying for the public that the beneficiary was no longer the bank, but rather it was some entity on Wall Street, then transferred to some entity on the Cayman Islands, then broken up into thousands of interests. They didn't want to be bothered to record those, because each time they recorded a transfer in the interest, they'd have to pay a filing fee. That was a lot of paperwork, and they didn't have time for that. So as they securitized and they dispensed with the original requirement under state law that every transfer of interest be recorded, they were essentially blowing up their own claim to the real estate. And more judges are recognizing that. But what it's time to face is the fact that when these banks started making contracts, knowing full well that the other party could not perform, that contracts were not being formed, that rights were not being transferred, and that the person who has the grant deed owns the property. Now behind me is the Santa Barbara Courthouse. And every day at 1 o'clock, if you go to the courthouse and stand under that giant arch, you will see properties being auctioned off. There's almost no one there to buy, but the auctioneers read a script that's almost impossible to understand, and at the end of each script, they transfer the ownership of somebody's house back to the bank for whatever the bank claims is owed to them. And the bank is not required to show in any way that they actually have an enforceable interest in that land. It's time for people to start showing up at these public auctions and asking questions and challenging the authority of these banks to take back ownership of not just hundreds or thousands, but in this country, millions of residences every year. Every year, millions of people are being thrown out into the street by banks who have already harvested the entire amount of the loan through their insurance and have no ability to show that they have any interest in that real property. This has to stop. The system is broken. It's time to build one that works. The reason I wound up in Santa Barbara was because when I saw this courthouse, I realized that this town had an incredible sense of community. When they built this courthouse, there were only 28,000 people in Santa Barbara. And yet they managed to combine their energy and their resources to build something that is this beautiful. And it is the most gorgeous courthouse I've ever worked in. I think it's time that we develop a stronger sense of community and recognize that we need to support each other and help each other out of this crisis. Just shortly before I went to college, this country was being rocked by the civil rights crisis. And somehow we managed to pull ourselves together and become a much stronger and more united nations. Well, we're at one of those points again where it seems to be dividing between the haves and the have-nots. The people who are still paying the banks are the haves, and the people who have no longer the ability to pay the banks are the have-nots, and they're not talking to each other. Well, it's time we change that. In your county, there is a courthouse where people are selling houses back to the banks every single day of the week. Find out when it is and go down and take a look at one of those sales. They put notices in the newspapers every day of the week. And there are millions of houses being sold now on the courthouse steps. We have to take back our property. It's being taken away from us by the banks, and we simply can't allow that to happen. Lawyers must remember the basic principles that they were taught in law school and apply those principles to this current crisis, and recognize that the rules that have guided the transfer of real property for hundreds and hundreds of years have been broken. And it's now our job to fix it and get back to a system that we can all trust, a system that works. So I'm inviting each of you to wake up and recognize that we are in a crisis. We must take action and get back on track before it's too late.